time, and as a defense attorney, you may have to rely on that stereotype and use your perimeter to get rid of that person.
Well, can't you make an argument, Earl, that in that situation, bluntly, you're using a pretext to possibly get to strike someone on the basis of race? I mean, we're talking about this, we're using obvious examples that, you don't want law enforcement, you don't want this, you don't want that. But part of the whole analysis under Batson and all the cases that follow and where we are now is the issue of people saying, oh no, I'm giving you a race-neutral reason, but that really is a pretext for not having a person of a particular racial background on that jury.
Well, I think that's where, people like the judge here have to step in, and when that pretext is given, and, really look at it and say, wait a minute, now you just exclude this person because he's a police officer, yet he's black, and yet there were 5 other white police officers that had a similar profile, you didn't exclude them. So why all of a sudden you excluded this police officer who's black, but yet you let the other white one sit? I think that was the issue in Snyder, where you had a situation where you had, I believe, an African-American college student who was saying, look, I can't give this trial that much attention I want to because I have a student teach. And the court accepted that explanation. And then on the Supreme Court said, wait a minute, you had a white contractor who expressed concerns about being able to sit on the jury, yet you let that person on. So why you let the white contractor on, but yet you exclude the student teacher? And his concerns were addressed by the dean of the school. And so I think that's where the judge comes in, to really be more assertive in addressing these pretexts instead of just taking it at face value to ask some follow-up questions at the trial court level, so there's a thorough record for it to appeal.
Well, let me follow up with that with man and time. Earl said that's where Judge Thibodeau comes in. I'm going to get to Judge Thibodeau in a minute. But Earl said, okay, that's where Judge Thibodeau comes in. He's the one who's supposed to hear the explanation, listen to everything, and then make a determination as to whether or not that person is actually using something else as a pretext to strike somebody on the basis of race. However, Justice Marshall talks about the fact in his concurrence in Batson that not only may you be dealing with a prosecutor who has racist tendencies or prejudices, etc., but you can be dealing with a judge who has the same racial prejudices or racial tendencies, etc., then how do we solve the problem? Shouldn't we just get rid of peremptories altogether? What if Judge Thibodeau is not good, honest, great Judge Thibodeau that we know him to be, but Judge Thibodeau has his own preconceptions about what African Americans may do on a jury, what this ethnic group may do on a jury, etc. How do you deal with that if you're trying to get to a fair trial? Now, in the employment context. Okay.
And one of the things that
what are you going to say? What are you putting on the record for purposes of the appellate court?
I will say this. One of the things that I try to do on any peremptory challenge to make sure it's my own due diligence. What are my reasons? If someone traverses me for this peremptory, I don't care if it's a supervisor in HR, and say if I'm the plaintiff's attorney, I'm not going to want an HR supervisor in an employment case. They're just not going to want it. What is the articulated basis for the appellate court, race neutral, gender neutral, ethnic neutral, whatever it may be, that would withstand scrutiny? If you read some of these cases for the reasons, and they're laughable that they offer. I mean, outright laughable. And so I think from my vantage point, what I try to do, what I would do if the judge, if I'm raising the argument of Batson, and let me say Batson cuts both ways. I've been in several cases where the plaintiff's attorneys have struck all the men in a case involving sex discrimination. And unfortunately for me, it was right before the Edmondson decision came down. And they struck every male. They just wanted females because they thought they would be more receptive. It backfired. The women were tougher on the lady than I think the men would have been. But my point is, I don't think, again, Kim, I agree with the practitioners. There have been many instances, and I think Earl said it best, you will have to either give more leeway to cause challenges, because in several jury trials I've had, I've articulated the cause basis. To me, it's clear as day. The judge says, no, man, use one of your peremptories. I'm going to make you use one of your peremptories. Without that, then I am stuck with some person who I am convinced cannot hear the case fairly in the back.
Well, Judge Thibodeau, no, let me interrupt for a minute. I'm going to get to Judge Thibodeau, Earl, then I'll continue my time. Judge Thibodeau, the practitioners have been very passionate Justice Marshall, let's get rid of them, how would you address the practical concerns that were very passionately articulated by Earl, Tom, and Nan with this situation? Do you propose coming up with the changes in relation to the definition of cause? How do you propose to deal with these what appear to be valid concerns of the three practitioners on the panel?
I'm a judge, not legislator.
Well, come on, give us some advice, George. Come on.
Yeah, but I get that. And I don't mean to be flippant about it. Nan indicated she would put on the record the reasons for the exclusion. And that may be well, but, Batson and all the various cases that have followed Batson in the last 23 years have said these race-neutral or gender-neutral reasons have to be either plausible, nor even reasonable. It's NOBS, unless someone specifically asked the judge in Article 695 of the Court of Criminal Procedure. Well, Judge, tell me, have the court or the plaintiff defendant explain specifically those reasons for the challenge. Once that trial judge makes that call, that trial judge is ruling on an intent issue. Intent is a factual determination. Okay? When it comes up to us at the appellate level, what am I supposed to do? The standard of review says, unless it's clearly erroneous, we must give deference to the findings, factual findings of the trial court. So those findings are almost immune from reversal or to reversal. Now, as a practical matter, what the U.S. Supreme Court has been doing really, while they mouth that standard of review, either the abuse of discretion or the clearly erroneous standard, if you read those cases carefully, what they're really doing is doing a de novo review. And I guess if you're at the Supreme Court, you can do that. But at the appellate level, we get our hands slammed if we do that. So the appellate courts are tied somewhat because of this abuse of discretion standard or clearly erroneous standard. It's very difficult to overturn that when we get that record on appeal. Okay, now to answer your specific question. What are some of the alternatives if the referee challenge was abolished? Well, you allow more, for instance, expansive attorney conducting voir dire. I know you've got serious limitations in federal court, but you can do it statutorily. You can do it statutorily. Allow much more expansive voir dire and attorney conducting expansive voir dire. You can do, as some states have done, Connecticut, Missouri, and South Carolina, all require prosecutors and litigants and attorneys to produce explanations whenever someone raises a Batson claim. Florida and Pennsylvania both require some evidence appeared in the record to justify one's reason, whether it's a prosecutor, whether it's a defense counsel, whether it's a plaintiff's lawyer or the defense lawyer. One may even have a Batson hearing outside the presence of jurors. I know that'll extend the time to trials and all that sort of stuff, but so what? If the cost of justice requires that, then it requires that. I don't mind what you think to review those records.
But Judge, what about the cause issue? I mean, Nan and Earl and Tom both said that if you did get rid of it, as you advocate doing, you have to tinker with cause as a basis for striking the jury. So how do you propose in the legislative role to deal with that?
You're correct. You've got to expand that challenge to cause. That is absolutely necessary. The current challenges were probably limited. You've got to. There's no other way.
And the judge, doesn't that apply in the face of what you said earlier about what do you do as an intermediate judge or any time? project.
It
Once
wouldn't-
that judge rules,
Sure, it wouldn't, we're not eliminating, this is, I mean, this is not, you wouldn't be